What is an issue is return to the property and what the other side would need to do. So what they would need to do is apply to the court for a restitution, a warrant of restitution. It's different to a warrant of possession. They would need to apply to the court for that. The problem that they'll have to apply to the court for that is argument in the court about the mortgage. So once if he's got those in play, then if they were to make this other application, it would be an abuse of the court's process because of his application in the court. Otherwise, they couldn't do anything with it until his proceedings in the court got settled, and then they could come back with that application against him. Yeah.
But like there were some people there today.
Right. Yeah.
Saying they come to take possession. So I went there, and there were like 5 of them.
Right.
I said, "Where is your warrant?" So he showed me a document. Yeah.
Yes.
I said, "Where did you get this document? What is it? Who gave it to you?" I said, we checked with the court. No one made an application for this warrant. So where did you get it?
Did you see the document?
Yeah. So,
and was it from a court?
I said to him, "Shove it up your ass and piss off and don't come back around here again."
Yeah, but when you looked at the document,
I don't need to look at it. They didn't make an application.
Okay.
They don't have a warrant, Selvin. That's the bottom line.
Yeah, but I think if you'd be able to tell what he's got or what he thinks he has, because he probably has something from an agency or something like that.
No, Selvin. He has something they made up in the back of their van.
I don't know. I simply don't know. All I know is that if they're going to produce something and it's with the enforcement of a court, it needs to be a court document.
Of course, it needs to be a court document, but you know where you said carry on.
But they wouldn't be able to do anything because almost sure all they would be able to produce is a warrant that was executed already. And it wouldn't be any good. It wouldn't be any good.
But you know where you said the original warrant that they executed is not an issue. I mean, what do you mean by that?
It's not an issue now because they went to the property.
Yeah.
And they executed it.
Who went to the property?
The court bailiffs previously.
Who said it's court bailiffs?
They went there previously.
Well, which court bailiff went there?
I think it's a county court bailiff. It's a county court bailiff.
Do you know the name of the bailiff?
No, I don't really. That's not really. You don't really need to know the names of the bailiff.
Of course, you need to know the name, Selvin. It has to be an appointed bailiff.
All you need is the warrant itself. Okay, so that's evident, and he's got one sent to him. And it is an original court document. You can verify that by going to the court. Then that's what they would have. But because I think what he said was they boarded it up, if I'm correct. They visited it and he re-entered it. Yeah, so they visited it.
Yeah.
And I think he went back in. He went back in.
No, I know he went back in, but the thing is, he was never out in the first place unless it was a authentic warrant executed by the appointed bailiff.
Let's put it this way. He got a possession order from the county court. That's it. He's got a possession order. They enforce possession orders with warrants.
Right.
They enforce that. And that's a document, and I think I have seen it in his case. It's simply a document, notice of eviction to tenants, blah, blah, blah. It's that document. They would use that to the premises.
The notice of eviction is not a warrant, is it?
Okay, it's called notice of eviction, but in the rules, it's a warrant. So when they put it on the document, they say a notice of eviction to occupiers, but it comes under the rule. It's actually a warrant. It's a warrant of possession. It is a warrant of possession.
But isn't a warrant an N235 document or something? N325.
I'm not not sure of the full number for that, but it just needs to say notice of eviction to the occupier, stamped by a court. And if it's got that and it's preceded by a possession order, that's all the bank need. And when they go to the property, that if they get obstructed, the police will come there to stop anybody from obstructing them.
Understand.
Right?
Yeah.
So all that person needs to do in reality is stand away. All they need to do is stand away, because when they've executed that warrant, they will leave.
Well, we had the police there. They never told us to leave.
Right. Well, maybe they probably didn't tell you to leave the property. I don't know. But all I'm saying is when they're executing that warrant, and because I know people normally just sort of stand there and say that you haven't got this and you haven't got that. They just need to stand back, because they don't realise that all the bailiff is going to do is execute it. And by executing it, they will drill the locks. All right, it's all part of that. They will drill the locks, and then they will leave the property. They go, they disappear, and all the person needs to do is re-enter it. It's called a self-help process. They re-enter that property, change the locks back. Now, the problem it has for the other side is that they will need to get a restitution. They need to get a warrant of restitution in order to gain the property. It's a civil dispute. They're all civil disputes.
What if they never had an authentic warrant in the first place, Seven?
I don't even think you should be concerned.
Really?
About the reason is because they got a possession order. You see, if they've got a possession order, they make an application in the court without notice, and all that will do, it will. I mean, sometimes they mess up a little bit. They don't serve a Dwellings Act notice on the property. If they don't serve a Dwellings Act on the property, then they can't. The warrant, they can't actually execute it because of the rules how they are.
But what if the warrant is totally false? This is my question.
I don't know. I mean, I think at the end of the day, I'm going to only say that you would have to just assume that their warrant that they've got, that they execute on the day, is what it is because he's got a possession order. And that's stamped from the court. And it follows. You can't get a warrant without a possession order. So
but you can get a false warrant on a possession order. You can make a fake.
I mean, at the end of the day, you can make any document you want to. Yeah, of course you can. There's no two ways about that. But what I think, just take that line to try and deal with his matter. It won't really help, and it will take the focus off of what the real issue is.
But him and his kids would be in the streets now. They couldn't earn money. They couldn't live. They couldn't do the administration if they were on the streets.
Yeah, but as I said, what they do is you re-enter the property. They're not in the street. You re-enter it.
No, they re-entered. After the court has refused a re-entry. So I looked at them. I looked at.
The court can't refuse a re-entry.
Well, I looked at the evidence and I told them to break in because it's all fraud.
Yeah, at the end of the day, the court will just issue a note that the warrant. The warrant comes from a court. It doesn't come from a party. It's not something that's delivered in the post.
But what if it's a false warrant, Selvin?
We don't know this.
I know this.
It may be. It may be. It may not be. You'd have to prove that it is false.
But who has it? Who has the burden of proof?
You.
No.
Yeah, because you're saying that it is fraudulent. So it's up to that person to prove it.
No, the aggressor has to prove themselves. Yeah.
No, it's okay.
You're in your home. You're in your home living peaceably, and somebody's come and smashed your door. They have to prove their authority, surely.
If someone smashes your door, they're breaking into it. But this point you're talking about here, I'm just trying to just to clarify. If you're making an accusation or a claim, you're claiming that a document is fraud. You're going to have to prove it.
No.
That's
I'm claiming it's fraud because when we go through a process to verify, it's failed. It can't be verified on any level. So therefore, it is fraud.
You have the evidence for that.
We have got all the evidence.
You have all the evidence to prove that.
Yeah.
You need to take it to the court.
No.
And prove and go to
you
the court.
You don't need to take it to the.
That way the court would have known it.
But isn't it a crime? Isn't it a serious crime rather than going to the court? It's a matter for the police. If they break your house on the false claim to an authentic warrant.
Oh, I see. No. I mean because it's a civil dispute. Because the whole of that matter is within.
Come on, Selvin. It's not a civil dispute. Someone breaking and going to children's bedroom. That's not a civil matter.
It's what is a civil matter is how it came about, and it came about in a civil court.
However it came about, the moment someone comes and breaks your door and can't even identify themselves, can't produce their warrant, can't produce nothing, gone up and down, leaving their footprints all over the children's bedroom and stuff, and even the cat flap they blocked. You can't call that a civil matter.
The reason why they entered that property is because of a warrant.
Exactly. Now, so where is it?
If you wanted to prove them that they were wrong, you would need to get the evidence and take it into the court and say, this was not correct. Here's the fraud. That's the only way you can do it. It's not. It wouldn't be a crime. You would not get anywhere if you tried to take that to magistrate's court as a crime, because they would look into the details of what happened.
Right.
And if they went through the details of what happened, they would see there's a purchase order, a possession order, followed by a notice. So the person that went in there, he went in there on an order of a court, a civil court. Okay? Now, if you want to prove that that is a crime, you're going to find that extremely difficult. You'll find that extremely difficult.
Is it because it's not a crime, or is it because of corruption?
It's not a crime, because obviously what they're doing is incorrect in that court system, but you've got to take the right angle to sort it out, and not stray. I mean, it's not a crime because it's a civil dispute of the parties. If someone other than those people broke into your property, that is a crime. There's no engagement with that person.
Yeah. Someone other than those people. Who are you? When you say those people, you mean the bailiffs?
The bailiffs, yes.
But how do we know they're bailiffs? How do we know?
Because of the possession order.
No. Do we know a bailiff, Selvin?
Because of the warrant.
We know a bailiff when he produces bailiff ID, no?
His ID, yes, but what he's acting off of? If he's acting off of a court document, then there isn't anything that you can do.
Let's leave the court document for now. The bailiff who broke into the house.
He's acting off of a
Forget where he's acting. Must he not produce his bailiff ID, his HMCTS ID?
He probably has got to do all that stuff. Yeah.
So where is he? Who is it that broke into this man's house?
I wouldn't. You're saying that they broke in. What has happened is they have enforced a possession order by a warrant.
So you don't believe they broke in illegally?
Not broke in, because the order from a court allows them to take the possession on behalf of the bank.
So you're still holding the line that they had an authentic warrant and executed it?
They've executed a warrant because he had a possession order.
Forget the possession order, Selvin. Do you think they executed an authentic warrant?
There's no point if you don't realize that there is a possession order. Because
I'm not interested for now. We have to cut things and deal with it bit by bit.
You need to follow the right path here.
They executed a warrant. So where is it?
The warrant would be with the court. Even you can ask the court for a copy of it. You can ask the court for a copy to see it.
And if the court don't have a copy, then what?
If they don't, we can't go by those processes. All I'm saying is you need the evidence to say, if you're saying that they haven't got one, you're going to have to prove it. And I'm saying to you that all that will happen is the court will produce, because they've got possession of, they'll produce a warrant. There's an order of a court going on. So at the end of the day, them people are acting by that.
Which people? Which people are you talking about here?
The bailiffs. The bailiffs.
Which bailiff? Who said it's a bailiff?
I have no idea.
Ah.
Turned up at the door, but that is not the point I'm making to you.
Well, to me, that's the 100% point, because I want to know who is it and what authority came into this man's property.
Okay, well, maybe the thing to do is, I mean, at the time, it's probably not possible now because they've left, haven't they?
No, but the court, everybody must have a record of it, from A to Z, from the claimant to the solicitor to the court staff. Everybody must have a record of this.
I don't think that like their solicitors would have a copy of a bailiff. I think it'd be to do with the court. So anybody that's appointed, because a bailiff is appointed through a court.
Okay.
So so it'd be for the court to produce it and say that this person actually is a bailiff acting on our behalf.
Okay, well, look.
It may even be that the bailiffs themselves have contracted it out to another agent.
And that would be legal?
Yes.
Okay.
It would be because they're still acting off of.
No, Selvin, you can't contract. You can't contract out account. You can't.
Wait a minute. Let me explain something to you. Let me explain something to you. Okay. Let me explain something to you. What clearly was not legal was the possession order.
Okay.
Okay. That wasn't. So that makes everything else that the bank has done illegal. Including the bailiffs, including everybody.
That I'm in agreement. I'm in agreement with that. Yeah.
That is what the focus should be, not on the bailiff per se.
But shouldn't we focus on the whole chain of events, A to Z?
If you want to get justice, you need to do it by the orders of the court. You need to do it by the processes of the court.
And if the process of the court is a fraud, then what?
Well, we could go with that conversation all day. Everything that is a fraud, nothing works. We can't look at the matter like that. We must look at the matter to find out if there is something wrong. If there's something wrong, so that's what we go to.
If he was following that now, he would be on the street with his kids.
No, as I said, what they're doing is not legal, but you re-enter a property and you take it back as self-help. That's what people generally do. They are not on the streets, now they're in their property. Here's what we're dealing with. We're dealing with people that have not accumulated the knowledge necessary to protect them in their properties before they get a possession order. We're dealing with after the fact. And that's why people fall into this issue. So, knowledge is everything. Had they known, of course, the possession order would not have been granted. It also means that although it has been granted, it doesn't mean that the person doesn't have a lawful remedy to it. He still does. They write into the system warrants of restitution, and the reasons why they write that in there, because people typically return back to their properties. They go back into them.
So what provision do they have in the system when it's a totally false warrant, false bailiff, false everything? What's the provision there?
Okay, for everything to be null and void is a case against the bank proving what the mortgage is. That is the angle you take, because that is the way you would get the court on your side and put them in a position where they couldn't determine it otherwise.
But if you're hoping the court to come on your side when the court is participating and facilitating all this fraud, why would they give you an order to say the mortgage is void? Okay.
If you haven't pushed your case through, you can't really answer that unless you've pushed your case through the court. I mean, what's really gone on a lot here, I'll come to the Benicia case in a moment, but what's really gone on is that people are getting thrown out, let's say, at the lower end of the court system where not much law has been done there. Okay, and it's become standard practice.
Right.
So all that lower court needs to see, I've got a bit of time. All that lower court needs to see is a deed.
Yeah.
All they need to see is a deed, and not really know very much about law itself. And use a standard practice to say, okay, I'm going to give an order for possession of the property, and on they go. They don't do law down there. All right, so
I get it.
That's the problem that goes on. But as you push through the system, you have to push through it, and you raise up and go through it. If anybody goes into the Court of Appeal, matters are tried completely differently.
Yeah.
And people are trained completely differently. We can't say that the whole of the court system is a fraud unless you've been through it.
Oh, but we're not saying the whole system is a fraud. We're just dealing each case on its own merit, you know?
Each case on its own merit, and according to obviously who's adjudicating on it. So back to the case of Bank of Benicia. An interesting case. My history of this goes back a little few years, Benicia's case was an interesting case. It touches on some things to do with law that the court can deal with, but also it deals with things which the court cannot deal with. So it was good in one respect. I think the only positive thing that I saw out of it myself was that it affirmed that a deed is where a contract must be signed. It confirmed section 2, anybody can go and look that up. It confirmed that. That's fine. That's pretty good.
Yeah.
And it by doing so, it affirmed that the document itself, that is a document, and if that document is not signed by both, the reverse will happen. You will get no legal interest. You'll get nothing.
Yeah.
So his case just showed that, because the judge was forced, in preference to the bank, mind you, but whatever, he affirmed that the deed was a document that complies with section 2. So his case was good, but I think where he made the errors was promissory notes. Okay? So I think he was trying to deal with the debt by giving the bank writing a promissory note for the bank. The court cannot see this. They can't adjudicate it. There isn't a law that can support it, unfortunately. I do agree that the banks are fraudulent for sure. Yeah. But you have to be pinpoint on the points of law that you're trying to deal with the matter on, and the only way to do that is that person has got to do his homework. He better know what he's talking about, because at that upper end of the court, you go, they're not idiots, right? They're not idiots. Yeah. And they're not going to put themselves in a position to be involved in a fraud. They won't do it.
Really?
The upper part of the court, the upper part of the court, the judges will not do it.
Okay.
Because they know what it is. They know specifically what what type of fraud is and what they're looking at. Okay, so that's a different. I mean, Benicia's case was good to a point. It was good to a point, but it's not the case to deal with the actual issue. And I'm going to simplify it for you as what that issue is. Yeah. It's to do with the reason why the banks are committing a fraud is because they're making false representations in their agreement, right? So that basically means that when you're making an agreement, like a contract, it must comply with law. It must comply with contract law. Yeah. Okay. Now, what's happened in the loan industry is that they say that they are going to offer you a loan, and they're going to make an agreement with you for a loan. Yeah. People do not realize that is a false representation. Yeah. And that in itself is fraudulent. Okay. It's fraudulent because you cannot create an agreement to do such a thing. Okay. That's it. That's how the law would work. All right. And because of that, that is what would undo anything that that bank has done or that loan company has done. None of these loans, none of them, okay, they're all false representations because of how a contract is established in law.
Yeah.
So if the person in grievance was to take it from that angle and not argue the point about he owes the money, they just do not understand. Money, if you receive money, that's not a debt. A debt is in a contract. They don't understand these things, so they can't argue them. So it just gives more power to the banks. On they go. They come back in that court and they will find something else because the argument's not right to take that property. Unless that is made clear or evidenced in the court, the person doesn't stand a chance. He stands no chance. This thing is huge.
What about a situation where the claim itself in the court is fabricated?
Okay, so to explain what happens when they bring into the court, that what they're doing, they're bringing a fraud. They're bringing a fraud on the court. They're bringing the fraud on the court because of the agreement, and it's a mortgage offer, and they don't have any. There's two things that they do when they bring the claims in. The first thing is there's two parts of law. They bring it in persona.
Well, they don't have a contract, so that's the end of the matter, isn't it? They don't have a contract. They don't have accounts to show how much is owed.
They bring it in personam, which is against the person.
Yeah.
And then they bring it against a property. So the reason why they're going for possession is they're bringing that against the property, which is a right in rem. Now, two of those things are separated in law, and they do not have a right in rem upon the evidence which would show them. So they have no right to take the property. Separately, there is no mortgage arrears because of legal obligations that don't exist. Third, there's a false representation that is made, which is a fraud. The banks stand to make out of that. Of course, they make a fortune out of it. Of course they do. So they're committing that fraud. That matter would end up in the Crown Court.
Right.
And someone would go to prison for it. Okay. So that's where it would lead.
Yeah.
But when they come into the court for possession, people make the wrong arguments all the time.
Yeah.
They don't bring in the grounds. They don't bring in relevant grounds, pertinent grounds that can actually deal with the case.
Well, I must say, right, then there's so many people who brought the case to the High Court, some with lawyers, some without lawyers, including the great Michael Obanisha himself. And nobody can get a bloody order that this thing is not valid,
Okay. Yeah, good point. Okay, so what you've got to understand still in the system, whether you're going to see an order like that, I personally don't think you're going to see it. You will not see it. So
the court is corrupt then? The court is itself?
No, not from the point of view that the court is corrupt, no.
Yeah.
Because of different ways of dealing with it. Non-disclosure agreements are made for that purpose.
Yeah.
Or a Tomlin order is made for that purpose. In other words, the other party, there's no chance of them winning the case. If they were to try such a case, you can't imagine the damage it would do. They're not going to give an order to damage the whole of the market. All that happens is a non-disclosure that would resolve that matter. That's all that would happen.
But they gave such an order to Obanisha.
Sorry?
They gave an order to Michael Obanisha, or his dad, or whoever it was.
So what was the order to do?
Well, to remove the charge of his property, null and void.
Okay. So what that was a legal interest in land. It's separate it does not touch upon any of the grounds to do with a fraud, okay? Separate argument totally went on. A legal interest in land, yes, because his deed was defective under section 1(3), and it was defective, okay? So that meant that they couldn't take the property away from it. It didn't mean that the mortgage, i.e. agreement itself, was not invalid. It simply meant that's what I'm trying to explain to you about rem and personam. So the issue of the right in property, the judge said that, okay, it can't happen. It can't happen because the deed was defective, and you need a legal interest in land, specifically a legal charge, not a legal mortgage. They're different things. You would need a legal charge. His issue concerned a legal charge specifically, not a legal mortgage, because he didn't have. They want mortgages, they were charging.
Yeah. Okay. So, but Michael Obernisha can't seem to get a second case through for some reason since 5 years now.
I don't know. I really don't know. I mean, the thing is, if he's going to have an agreement, and that agreement is going to have from that bank is going to be to loan him money. Yeah. Okay. So I don't know what he's done or what that case has gone, because I look at specific things and simply deal with those. But it's a matter of how it is posed. Equity, okay, is what rules, if you like. Yeah. So if a party, if you're trying to buy a property, and you don't yourself create an equitable interest in that land, you will have no right in it. Yeah. No one can get that. Banks, no one. You need an equitable interest in land. And what a legal interest does, it's additional enforcement. So if you've got an equitable interest, then they can get a legal charge. And under Section 87, they then can take the property because it has the rules there that provides for them to do that. Okay? So it just meant in his case that they couldn't do it. But whether, I don't know how he got on with the banks, because they would come back at the end of the day. They're seeing that they would have an equitable interest, and they would know that they've got this equitable, and that they would probably come back after him. So what he can do about that, I don't know. The matter rests in equity. So if the agreement, which is one document, and it incorporates a deed in it for additional security, that is a single document. A court of appeal have not tried a case where that exists. They've only dealt with Helden, and Helden is not such a document. It doesn't incorporate a contract to create a legal interest. So these things are different. If they went into the court of appeal and those points were put, of course the person's case would be different. Yeah. This thing is very specific, and one really needs to know what they're talking about and what they're doing going forward, and not fall on a side where it's really going to probably lead them nowhere. It will lead them nowhere. They need the power of the court. We don't have anything else. The court is there for it.
But are you aware of anybody who has achieved this matter? A resolution from the court. Okay. Well, you did say earlier that
if it has, you will not know. Yeah. You're not bound to know this, as I'm trying to explain, because justice must be seen to be done. So you're not bound to see this. And if the system is to keep running as it is, that's got to be a non-disclosure. It's got to be a non-disclosure, which means you think that no one has got any result from it, which doesn't mean to say they have. But if you understand the processes and what's involved, the only thing that you could do is non-disclose an agreement like that. And that person who's got that non-disclosure can make no comment about it other than his case has been settled.
But I'm familiar.
He cannot go anywhere.
I'm familiar with so many cases and groups and WhatsApp and Facebook, and I've never sniffed anyone. I've had several cases where I got offers from the bank for clients to settle on a lower figure and stuff, but generally I don't think
if you check, you're not going to find, if that's the case, you're not going to find any of the evidence, witness statements to particularize what I'm saying to you. Yeah. That is the reason, because the court has to follow that procedure and it has to follow law. But if it's not presented to it, it won't do it. You go into the court, all that judge is going to do is he's going to fall on the side of a bank. He's naturally going to do it. He's going to default that way.
Even though the bank is in the wrong, he's going to fall on their side.
Because the proof is what you must produce. You've got to produce, and that's the thing. The bank is almighty. You've got to understand at the bottom is standard procedure. When it goes into a county court judge, it's a standard procedure. All right.
But I call that fraud.
If you want to back them up, you've got to change. You've got to change your.
You call it standard procedure. I'm calling it fraud because what you're doing, you're violating the Constitution. You know.
Well, whether that is fraud in itself, I mean, you see, if they err on their judgment, or they simply say no, I think it's this and that, the system has a right of appeal.
It's not error on the judgment. It's just totally fabricated cases. That's not an error. They may deliberately. What I'm saying is they may deliberately avoid the issue. They may deliberately do it. They can avoid the issue, but I don't have to avoid it. It's a fraud case. It's a fraudulent. You didn't have a contract to file. You don't have.
Well, that's nothing to do with the judge. What I'm trying to explain to you is that the judge himself, looking at the evidence, he can treat it a certain way and say that he's decided it's not right for what he's basically opinions.
Can the judge facilitate fraud?
They won't facilitate fraud, no. I mean, if there is such a thing, because they'll just say, right, take it to the Court of Appeal, they'll straighten it out, and then the Court of Appeal then will have words back with that judge who didn't get it right. That's the court system that we have. But what the judge wouldn't do is argue a point of fraud on behalf of the bank once you've pointed out what that fraud is.
It's a false claim. The claim, like we're talking about the warrant earlier, they don't have no warrant. There's no county court bailiff appointed.
You're talking about a warrant, and I'm trying to explain to you, you are going down the wrong path with that. If you're trying to deal with the case objectively, that is the wrong path to take.
Objectively means it's a false claim. That's the objective.
You have to go to the section to prove that, and it's not at the warrant stage. That's just the court going through its.
Well, if you come to my house with a fake warrant, and nobble my children, I'm very sorry. It's beyond fraud.
Okay, but you're failing to understand the bigger picture here. You really are failing to understand.
You think fabricating a warrant, there's a bigger picture than that?
What I'm saying to you is you're focusing on the wrong side of it.
No, somebody came through the man's property and said they had a warrant. That's what you got to focus on. Because no matter how much fraud.
If someone comes to your property and they say they've got a warrant, and there's a county court judgment from a court, okay, and it's that warrant is what is enforcing, the police themselves can check that information out. All right.
Look. So what you're saying, what you're saying is, oh, blah blah blah. I'm talking the warrant on the prima facie. It's not a warrant. It's a piece of toilet paper. The bailiff can't identify himself. He's not been appointed the bailiff. They can't show ID. They can't execute.
You are fighting from the wrong end.
No, I'm fighting anywhere I see the fraud.
Okay, but what you're going to do is make your situation never get resolved.
Okay.
The reason is because you've gone to the wrong side of it.
Okay.
And all that happens is the banks still have the power.
So you think this you think this victim should move out with the kids, just move out then and leave the property?
No, that's not what I said to you.
Okay.
Don't misinterpret what I'm saying to you.
But then if I was going by what you're saying, they would be on the street now with the kids.
No.
Okay.
What I'm saying is that the people self-help and return. They drill the locks back out, put the locks back down, the person comes up, they collect it, and off they go. That creates a separate problem, because you've got to understand that when they take the property, they want to sell it, right? So they'll put it on a estate agent and stuff like that. And the estate agent can't get to the property because there's someone in it. Now, the only thing that the banks can do is go back into the court, or whoever says that they've got a charge is to go back into that court for
but they never went in the court in the first place. They don't have no warrant.
I'm trying to explain to you, he's got possession orders.
I don't care. Show me the warrant. You came in my house. Show me your warrant. Surely.
I'm not the bailiff. I didn't come into your house. What I'm saying is that they issue possession orders.
Look,
and these possession orders
I don't even accept.
What you are doing. Okay. Listen, I can't really.
Yeah.
All I can simply say to you is that if you want these matters to be resolved, even though they've come to your property, you can reclaim that property. It's simply called self-help. People do it all the time, but it's what they do after that makes the difference, because it doesn't go away. And if you're at the wrong side of it, you're never going to resolve it.
So if you take your property back, you mustn't make any noise about the fake warrant and the ID of the bailiff. Okay,
so what's happened is, once the warrant is executed, you can forget the bailiff because they've executed it.
But where is the warrant that was executed, and who is the bailiff who executed it?
Whoever he is, he's a bailiff.
Anonymous bailiff? Anonymous bailiff?
Yeah, but if there is a warrant and it's been executed,
if there is a warrant, which warrant?
Okay, if they've got a possession order, I would suggest that you just simply go to the court. If you've got a problem with that, I would suggest.
He does not want to question the warrant. If there's a possession, show me the application, show me the fee that was paid, show me the warrant that was executed, show me that the bailiff is his ID, his HMCTS ID, show me the EX96 document which hands possession back to the so-called lender. So this guy don't want to deal with this. He has some secret ways that will be secret settlement, blah blah blah. Look, if you can make a fake warrant and break into somebody's house and nobble their children, you must go to jail. God bless. Thank you very much.